This is the second effort to respond in the course of this. The first one was recorded, and again, somebody took the voice file, which I understand, is part of what is wrong with this process. I'm looking at an opinion issued on October 25th, 2018, in the case Romero versus Batra, allegedly about a divorce proceeding. That is not what this is about. This is of specific concern because I recently found information about a municipal bond fund that has a major benchmark on October 25th of this year. And I also last year attempted to submit an appeal to a case in the federal district court here in Dallas that had a response on October 15th of 2019. This case is presumably about a divorce proceeding, but that is not what it is actually about. It is specifically of concern because in this case, it says, in the case, Romero is representing herself on appeal. Although we liberally construe pro se briefs, we require pro se litigants to comply with applicable laws and rules of procedure. Wheeler versus Green. However, when I submitted my case pro se as in a request for new trial to the district court system here in Dallas, I was given a response by a magistrate judge that had violated the procedures of the local rules here in Dallas, as well as the applicable components of the federal rules of civil procedure that was cited specifically in my request for a new trial regarding of concern, specifically use in derivative action, and said specifically that pro se litigants were held to a lower standard. Additionally, in this particular motion, it says above information about this case that is factually incorrect. I was a witness and offered myself as an expert witness in this case in the summer of 2017. At that time, Romero was representing herself pro se in a variety of pieces, in a variety of cases, including one that involved a judge that I ended up submitting a disciplinary grievance to the State Commission on Judicial Misconduct in consideration of the fact that the judge had engaged in numerous inappropriate endeavors, including in response to an appeal filed in that case and how the court handled the attempt to file an appeal regarding his order. In this particular motion, it says the case proceeded to a trial at which Batra prevailed. The trial court judgment declares that, quote, no informal or common law marriage has ever existed between Romero and Batra. Orders that Romero take nothing on her claims and awards Batra a court cost of $25,000 in attorney's fees. The thing about this is that no informal or common law marriage has ever existed between Romero and Batra. Their full names are used, is in quotation marks. That was in the original notice by the judge to whom or against whom the appeal was filed. But the rest of this information was in a separate order. That might be why it's not in the quotation marks, but the point of the matter is that what this refuses to acknowledge is that that judge and that order was appealed, and that upon the appeal, the means by which the judge responded was so egregious that it had to be reported to the State Commission on Judicial Misconduct. Now, presumably, they opened up a report, and then they closed the report saying they lacked jurisdiction, but that turned out to be factually incorrect as well, as I followed over the year. I've watched this case and other cases connected to it for the last several years. They were using this case. This is not a case about a dissolution of marriage or even about a divorce. This case was about the respondent, her husband's lawyers, and him engaging in variety of litigation efforts that served to traffic her two children for Medicare and pension fraud. As a matter of fact, there was an appeal that was submitted to the Supreme Court of Texas requesting a petition for a writ of Mandamus to consider this case from a perspective of understanding that what was really happening is that the lawyers, along with the husband, were trafficking the children in order to, and the mother, in order to create a variety of circumstances under which they could traffic the children. This is evidence in the report, or in the writ of Mandamus that was filed before the court and that was denied. Not only that, but during the course of that, I was witness to how she went on site to the Supreme Court of Texas and paid the filing fee in person. And they gave her a receipt that had a different case number. And I've watched until this year how that case and this case have been used in conjunction with other derivative processes. And after she received that receipt for the payment on her case, then they required her, they sent another notice that she owed a filing fee. So she went on site, she paid, and then they assigned the payment to a different case, and then they put an act of fraud in that case, saying that she owed a filing fee when she did not. She had already paid it by the time they made that notice about her paying the filing fee. This is part of the manipulation of legal process that was she was subjected to, as well as what her husband's lawyers ended up doing. The principal in the firm for her husband claimed that he was an expert on legal fees. In addition to that, there were other matters that were taken advantage of in the course of this case. You know, if I file an appeal from a case that was abused through the Texas Supreme Court system with the district court, and I get a magistrate judge that violates the explicit rules of civil procedure, which is where I originally filed the case requesting a consideration for a new trial, explicitly violating the rules not only of the local court, but the local court rules, but also the rules of federal civil procedure, as was explicated in the case. And I'm told in a formal opinion that's backed up by the presiding judge that there's lesser standards for pro se litigants. And I'm a first language English speaker, and I'm a citizen of the United States. Then what courses, and I don't have children, I don't have these extenuating circumstances and these additional pressures that you could put on me in order to try to coerce me into conceding on my rights. What right do they have to say we require pro se litigants to comply with applicable laws and rules of procedure in a manner that is accepted from a different standard to which somebody would be held in the same sort of consideration? She was denied any representation the times during for the times she was going through this custody proceeding with her children. She had originally had an attorney. That attorney dropped out, and they subjected her to these very illegal procedural motions that they were allowed to get acknowledged as legitimate in the court, while she was denied all representation. As a matter of fact, if the motion for a writ of mandamus had been taken seriously, part of the consideration would have been a request that the deposition that was used in evidence in order to justify her husband's claims regarding that no informal or common law marriage had ever existed would have been disqualified, because there were 3 different instances in there that the lawyer who was performing the deposition knowingly and willingly engaged in activities that a lawyer would have been able to have identified and had cited to disqualify the deposition. And she demonstrated, despite the fact that she was not a first language English speaker, that she understood that he was engaging in things that were procedurally errant. But I understand and believe that he relied on the fact that she was denied any legal representation to lack any standing to challenge that for its submission as evidence and get it disqualified from consideration. Not only that, I believe that what he did was so egregious and such an egregious breach of professional ethics that the transcriptionist in that deposition quit after that. And these are the things that should have been considered if there had been a good faith effort to engage this in a legitimate legal process. There's nothing legitimate about this legal process. All it has done is serve to create derivative litigation that's actually about tormenting a person who's been subjected to these actions in their real life, and engage in processes that have, for at least the last 3 years, served to traffic her and her 2 minor children for crimes connected to abuse of financing and funding concerning access to Medicare, and using misrepresentations of obligations that the father had to pay for health insurance based upon his participation in a professional society or a union or labor organization to which he would have been required to be a member in order to be determined for the amount per month he was required to pay. And by virtue of the fact that none of these so-called legal experts ever acknowledged that he was completely in non-compliance with the parent-child agreement by refusing to pay for their medical insurance, which was a component of the child support he was required to provide, and instead forcing her and her children on the Medicare the entire time that this litigation was going on, demonstrates that the attorneys, including the principal in that case, knowingly, willingly, allowed for misrepresentations of the facts of the matter to be masqueraded as if they substantiated any of the claims in this case, and everything they did was an abuse of the legal process. Now, we are where we are. My understanding is that the concern I have is I have watched how benchmarks in this case, dates and anniversaries in this case, have been used in derivative processes connected to other cases. And I'm very alarmed, especially now, because this is honestly the first time I've been reading through this particular aspect. There's other motions in this case that I've followed, and they have harrowing implications enough. But now that in the last 48 hours, specifically in reference to Hurricane Laura and the devastation connected to that, this case and the matters of which I am speaking, including the attempt to file before the Supreme Court of Texas the writ of Mandamus requesting consideration of the charges of trafficking of the children, happened prior to and during an emergency situation. I'm also acknowledging that this is the second attempt I made to discuss this, and in the first attempt I made to discuss this, I did not mention the emergency situation, and I gave more context to the understanding that there was an abuse of the State Commission on Judicial Misconduct in the manner in which they handled the request for consideration of an investigation of misconduct by the judge involved in this case before this was allowed to get to the Supreme Court level.